Welcome to Swala Nyeti, the law podcast that pairs a layman and a lawyer to answer your legal questions of the day. Swala Nyeti is sponsored by the law firm of Kigwata and Company Advocates and is intended for educational purposes only.
Welcome to Swala Nyeti. It's the layman versus the lawyers on Workers Wednesday, and today we'll be discussing employment and labor-related issues, and we are joined by Anyango Koile, a commercial lawyer. Welcome to the show.
Hey everyone, my name is Anyango Koile, and I have been invited by the hosts of Swala Nyeti to answer the legal questions today for the layman.
Question number 1. If I take up a promotion at my workplace where I am placed on probation, does it mean if I fail, I lose even the job I have now?
Probation is often issued when there's a misconduct at work and you're given time to correct the misconduct, or the employer needs time to decide whether to keep retaining you or not. If, let's say, the employer decides to terminate you, of course you're going to lose even the promotion you have in that same company, if that promotion you were talking about was in the same company or institution. So if the probation doesn't go well and you're terminated after the probation, you are going to lose even the job that you have right now.
Question number 2. I give sexual favors to get my current job, but now the boss has become too much. What are my options?
So basically, what this is termed in law is sexual harassment. So sexual harassment just entails direct or indirect requests for sexual favors at the workplace by either your employer or a co-worker in order to grant either favors such as giving a job, getting a promotion, or issuing preferential treatment at the workplace. So in most organizations with over 20 employees, a sexual harassment policy is required to be put in place by law. And this means that the human resource management will put in place a policy where you can address all your sexual harassment issues, which means the first option you have would be to report him to the human resource management department, and this report or the claim will then be investigated without you being revealed. They will advise on the way forward. You have to let him know that you do not appreciate the advances, and you should also keep the text messages or the emails or the videos or any other conversation that you have that will be evidence of the sexual harassment in case you want to make a complaint to the labor officer or file a suit in the employment and labor court reporting that you have a dispute for sexual harassment by your boss. The only bad thing with this kind of situation is that in the first place you gave out sexual favors to get the job. In law there's something called equity, and equity, you get what you give. So the most favorable option would be to first report the sexual harassment incident to your human resource management.
Question number 3. A casual I hired fell and broke his arm during loading of goods into my shops. I compensated him with a full month's worth of pay. Is there anything else I need to be worried about?
This is such a good question. This entirely depends on the extent of the injury. If he injured his arm, we have to consider if the injury caused a permanent thing or a temporary one, and the amount of money that this worker put into his medical treatment. So the worst that can happen in this scenario is that the employee decides to sue you in a civil suit for compensation, in which case the court will consider a lot of factors before deciding whether or not to enter the judgment in favor of your employee. Well, according to the Work Injury Benefits Act, every employee who is injured at the place of work has to be compensated, has the right to be compensated, which means if the money you gave him wasn't enough to cover his bills and he decides to sue you, you will definitely have to worry about giving a higher amount than what you've already given.
Question number 4. If I work in my own company but take out money only when there is a profit, do I have to pay P.A.Y.E and other statutory deductions?
This is another good question. So basically in law, a company is considered a corporate individual while we are considered natural persons. A company is considered an individual separate from its owners. That means that if you have a company, the company will have to pay its own taxes, and you, being a separate individual, although you are the owner, you will have to also pay all the taxes that individuals get to pay when they're employed. My answer would be yes. You have to pay taxes for both the company and yourself, or you will have committed an offense in law.
And question number 5. How often does a labor inspection need to be done if I was found compliant the first time?
So the law provides that an inspection can be done at all reasonable time. And looking into the meaning of the word all reasonable times, it could mean any time as long as it's reasonable. The inspection will be done with prior notification to the employer or the employer's representative, unless the labor inspector thinks that this prior information will prejudice or defeat the object of his visit. So a labor officer is allowed at all reasonable times to enter, inspect, and examine any land or building or structure, whether permanent or in a place of employment, and may make such inquiry, inspection, or examination as may be necessary to enable the labor officer to determine whether the provisions of the Labor Institutions Act or any other labor law are being complied with. So the answer is yes. The labor inspector can come at any reasonable time.
Thank you very much, Anyango Koile, the commercial lawyer, for joining us on today's episode of Workers Wednesday on employment and labor-related issues.
Thank you so much for listening today. I host another show called All Things Legal P.A.Y.E. if you are interested to listen. Thank you and have a good day.
And thank you all our listeners for tuning in to Swala Nyeti. We hope to see you again. On Thursday, we'll be discussing Traffic Thursday, and we look forward to having all of you. Once again, from all of us at Swala Nyeti, have yourself a lovely day. Goodbye.
You have been listening to Swala Nyeti. If you have a legal question that you want answered, send us a WhatsApp message on 0708 111 222 or email us at admin@swalanyeti.org. You can find downloads to all our podcast episodes on our website www.swalanyeti.org.